My name is Elena Fedoruk. I am, since yesterday, I'm the president of Association of Lawyers for Online Business. Yesterday, in the International Day of Intellectual Property, our Minjust, our Ministry of Justice approved our association, and it's my book. It's the first book about law. Очень волнуюсь. Low maintenance, I think, maintenance of online business. So last year we talked about problems with artificial intelligence and advertisement. If you listened to me last year, you remember that I told you about mistakes with AI and with advertising, and AI thought that honey and onion are sexual objects and blocked the advertising. That's why entrepreneurs in America got losses, and it was a big problem, and it is still a big problem. And this year I want to discuss with you problems with copyrights with artificial intelligence. I think everybody also join to our discussion and will write something in our chat. And there are many words, many topics I want to discuss with you, such are opinions, criteria, trends in science and in international law practice. So oh, thank you for your congratulations. Let's start. A couple of decades ago, we couldn't imagine that the inventors would be happy for the acceptance of a tool created by themselves as an author. I mean artificial intelligence and such inventions designed through the work of algorithms, and these algorithms embedded in AI. However, with the development of technology, the world scientific community and AI owning companies are increasingly publishing new reports in which exactly the AI is indicated as author. I think it's quite strange, but there are so many news about it. We can't, we all see them, and it's exactly not one news in a year. From recent, in September 2021, scientists from the Federal Polytechnic School of Lausanne, resorting to the help of the orchestra, presented to the audience an excerpt from Ludwig van Beethoven's 10th Symphony, and it was generated as a result of the authorship of AI created by it, and this AI called Beethoven. Do you know some AI which are broadly known maybe you will write about such of examples. And what kinds of AI programs do you know? I think who has iPhones, they know about Siri. Who use Yandex, they know about Alisa and Yandex Search. I see, yes, Alisa. Actually, there are lots of them, and you can try almost all of them. So Tinkoff Bank produced Aida Pushkin. You can write the first sentence for a couple of words, and this AI will create from your words a little poem. So Beethoven, they said that it is the author of the end of 10th Symphony. 10th Symphony wasn't finished by Beethoven, and Beethoven finished it. So Yandex YLM, it's a language model on which the program runs, and it's based on 3 billion parameters and trained on parts of Wikipedia pages, news articles, books, open interests, and in social networks. And with the help of the same technology, answers from Search and Alisa have been formed since 2021. So when you use Yandex and try to write a letter, email, you start to write something, and the next word is suggested by YLM, this language model. And a year later, in summer 2020, were the news about the first registration of a program written by artificial intelligence here in Russia, in the Russian Patent Office, and it flew around the world. Sber AI has registered a program with Rospatent that allows AI to recognize and analyze objects in virtual reality. However, among the software developers in the department, not AI is indicated, but Sberbank employees. It was they who taught the neural network to write program code. It is impossible to ignore, and perhaps the most ambitious example of providing the authorship of AI in word practice is Steven Tyler and its DABUS. DABUS is the device for autonomous data loading, and for a couple of several years, Steven Tyler tries to get patents for DABUS, and further I'll tell you about his господи. Successful attempts, and then we go about opinions and criteria. Ryan Abbott, professor, says if you don't have a traditional author, you can't get the copyright protection in the USA. It's true. If you don't have someone who traditionally meets the criteria of a human inventor, you can get a patent for anything. So another opinion by Mulina, and she says that artificial intelligence is constantly growing and developing, and this can lead, for example, to the creation of such artificial intelligence who will train other computers, create new works. And in this case, the situation with the exertion of AI copyrights may become more complicated. I don't want to believe in this, but there are many opinions between scientists who investigate AI and IP in this sphere. Another scientist, Arteni, his surname, he writes, artificial intelligence can seriously change the copyright systems, and Arteni suggests calling the process of creating intellectual property or objects by AI with a new term. He suggests to call it generation of works of science, literature, and art, and components of programs for computer. And he suggests to fix it at the legislative level. Then Chuyeva, another investigator, speaks about the readiness of factual and legal basis for recognition for copyright AI. The most correct solution would be to recognize the existence of exclusive rights to the result of intellectual activity generated using artificial intelligence for the developer of the corresponding artificial intelligence. There are many problems of authorship of works created using artificial intelligence, and there are subjects of many modern scientific studies. I read articles, and the number is growing and growing up every month, every week. I don't know why, but many scientists want to name AI as an author. And I see that the process of humanizing of AI is here on our eyes. There are many articles and many investigations. I think that there is no reason to talk about all them, and their number is growing. And there are criteria. The criteria formulated in the resolution of the European Parliament in 2017, number P8 TA Proof 51, norms of civil law and on robotics, and it's classified for 4 criteria: think like a human, think rational, act like a human, and act rational. I think it's impossible, but okay, let's go further and let's use the definition. The definition from this resolution of European Parliament, it sounds in such words. Just a second. Characteristics of smart robot: the ability to become autonomous using sensors and or exchanging data with its environment, compatibility, the ability to exchange this data and analyze it, the ability to self-learn based on and accurate experience and interaction. The presence of at least minimal physical support, the ability to adapt their actions and behavior in accordance with environmental conditions, the absence of life from a biological point of view. It is not alive, but it is autonomous, and it needs minimal physical support. This is a big problem. On the one hand, they say that AI is autonomous. On the other hand, still they say about minimal physical support. Isn't it strange that autonomous object needs minimal physical support? For example, if you put a man deep in the forest somewhere and leave him alone there, we human, we have sources, and we have memory of thousands previous generations, and we can be autonomous. We can eventually find fire, water, and some food. We can make for us some things which tools of labor, and we can be autonomous in 1000%. But can we say that smart robots and artificial AI is autonomous at all? When we talk about minimal physical support, for me, it's strange. I am very interested to hear from you. What do you think about it? And by the way, our history has many examples of attempts to recognize the authorship for technical solutions. None of them succeeded until 2018. So long time ago, back on March 17th, 1884, when the Supreme Court of the United States, in its decision number 18 on the claim of the lithographic company Barrow Giles versus Saroni, Supreme Court identified the photographer as the author of the work created with the help of the camera. So in 19th century, people tried to prove that the camera is such a thing who produces photos. If you think that it's strange, okay, you're right. We all know that a human, is an author. And if he uses camera to help to create such photos, not camera is the author of photos. Another example, more
recent or fresh?
More modern, fresh. I wanted to say fresh, but not academic, modern. In 1966, in the MIT Artificial Intelligence Laboratory, Joseph Weizenbaum created the program, and he called it ELIZA. What did ELIZA? What do you think it was about? ELISA modeled question phrases, and it helped to people who need psychological help. And people talked to ELISA like maybe now they talk to Alisa or Siri if we talk about iPhones. And in 1966, the ELISA became revolutionary program, but Joseph Weizenbaum didn't claim to be independent, but ELISA, with the help of Joseph Weizenbaum, did not claim to be independent and a replacement for a psychotherapist. A human needs a human, and we all know it, and ELISA can't be despite its autonomic, it understands you, okay, it's not a psychotherapist. And as for modern law enforcement practice, let's focus on 3 cases that have already become landmark in the issue of granting AI copyrights. And the first was considered by the court of Shenzhen, China, Guangdong province, which ruled that a work created with the help of artificial intelligence is subject to copyright protection. Actually, I talk about the case of Tencent's lawsuit against Shanghai Yangsan Technology Company. What happened? Tencent has a dream writer. Dream writer is an artificial intelligence, and it generates new materials from 2015. And on August 20, in 2018, dream writer wrote a financial report that includes the Shanghai index for that day and the information on currency exchange and financial flows. As stated in this article on the Tencent Securities website, the article was automatically written by Tencent. The Tencent is an owner of Dreamwriter, robot Dreamwriter. But that didn't stop Tencent from suing Shanghai Yangsan Technology Company, which copied the robot's article to its website. As a result, the court of Shenzhen Nanshan district stated that the defendant, Shanghai Yangsan Technology Company, violated copyright Tencent rights and must bear civil liability 1,500 yuans, some more than $200. The court awarded a fee for economic losses and as compensation for violated rights. And it should be noted, and it's important, that the beneficiary of such money, of this money in this case, was the company owner of robot that generated the content, not Dreamwriter. Tencent got a compensation. What criteria have become decisive in determining the authorship of AI in this case? The court points that the form of expression of the article meets the requirements of written work, and the content indicates the selection, analysis, and evaluation of relevant information and stock market data. The structure of the article is reasonable, the logic is clear, and there is a certain originality in it. So, Robert Dream World created an article which has criteria of originality and has copyright. So second example, second law enforcement regarding to the authorship of AI appeared to the world in South Africa. Patent for an invention authored by Dabus, by Steven Tyler, and it was the first issued patent for Dabus. The process was initiated by Steven Tyler, the developer of Dabus, and he had, before this case, Steven had been trying for several years to obtain a patent for the invention of a food container based on fractal geometry on behalf of Dabus. He applied to the USA and the UK. The High Court of England and Wales rejected 2 patent applications of Tyler, stating that AI is not a natural person. So if you are in England or in Wales, you should be a natural person to be an author. And therefore, Dabus couldn't be considered as an inventor in accordance with the UK Patent Act 1977. The European Patent Office also rejected the application of Tyler. What it said, cannot claim legal ownership to their products because AI systems do not have legal personality. So natural person, legal personality are the reasons why they rejected the application and the claims. Patent Office of the United States has stated that AI doesn't meet the definition of a concept that usually defined as a mental action performed by the inventor. So Dabus could not cannot do any mental action, cannot perform. And the experts of the Patent Office of South Africa, guided by the opinion that creative machines can process and critically analyze data, learning lessons for them. This process is known as machine learning, and they decided to grant Steven Tyler patents for inventions, and the author of which is specified in the application as Dabus. This third example, the short positive opinion regarding to the authorship of AI, was expressed by Federal Court of Australia. You see it you see it here in the presentation. Dabus was also recognized as the inventor. And in this decision, perhaps the most interesting and the detailed justification of criteria for granting AI copyright. It was overtuned. It's a big happy for me and for investigators that have the same point of view, but what the Court of Australia said to us in its decision. The inventor may be an artificial intelligence system, but in such circumstances cannot be the owner, controller, or patentee for a paintable invention. 3 criteria there were. What did the court of first instance say? So did you understand that it was overtuned? And now I think we should know the three criteria on which based its decision the court of first instance. Okay.
Sure. Yes, we understood that the first instance decided that AI can have a patent, but then this decision was overturned. But we will have a look at the decision of the first instance to see the arguments. Okay.
Okay. First, an inventor is an agent. And an agent can be a person or a thing that invents. Second, this interpretation reflects the reality from the point of view of many other patentable inventions, in respect of which it cannot be reasonably claimed that the inventor is a human being. And the third, the most interesting criteria, there is nothing in the law, meaning the Australian Patents Act Regulations 1991, does not contain a reverse output. What do you think of it? I'm shocked. And I'm really happy because the appeal instance overturned this decision. So, some more words. Is the AI really autonomous? The inability of AI to have legal personality and act is also based exactly on the absence of real autonomy. The science did not form a unified understanding of autonomy and began to consider it as a matter of course when describing AI. What is the real autonomy? What do you think of it? I said that if we put the AI deep in the forest and let it be there, its mistakes, its inability to adapt to environment won't give a chance to AI to live and to prove us that it can live without any support. So, and almost thank you. I think that algorithm-free creativity is possible only on the part of the human author, not the AI, even the smartest one AI. AI doesn't have more data than is loaded into it. So we all know that first you feed the AI, you put their big data and algorithms, and after that it can do something, but it has no more than it is loaded into it. And only man reveals new knowledge. As in the 3rd century BC, Archimedes has exclaimed, Eureka! And to nowadays, inspired by creative impulses, scientists make great discoveries, and these discoveries are unlikely to ever become available to AI. That's my opinion, and I tried to show you why. Thank you for your attention.
Helena, thank you. Thank you very much. We really do welcome questions in chat. And I also have a question. So we understood your opinion on rights to creations of AI. That's definitely clear. Thank you. I totally support your opinion. I know that WIPO, World International Property Organization, also gathers opinions of experts, but I didn't follow the question. Do WIPO now has any just I don't know, some agreements or some kind of treaties or recommendations concerning artificial intelligence?
Well, there are so many definitions, there are so many recommendations, because it is discussed in USA Congress, in Europe Council, and each of them provides its own recommendations and criteria. I still write the dissertation on the responsibility of AI, and maybe next year I finish it and tell you about all these recommendations and criteria. Not today, okay? Oh, Karina.
Okay.
Karina,
what do you think? People widely discuss the rights.
Right? So in I want to start with an example. Since 2011 till 2017, there was a long precedent case about monkey selfie, and the photographer David Slater, I think it was David Slater, he left his camera in the area where monkeys were, and macaca Naruto, it was called, she came to the camera and made some selfies, and people tried to imagine to present this macaca Naruto as an author, but and there were many courts, but the court said that no, it was an random chance, an incident, but not a directed act to create this photo. So, and in case when artificial intelligence investigates something, the author is not an AI. The author is a man, an investigator who loaded the data and the algorithms in this robot, in this machine, in this neural network, but because it's not a creation, it's the generation, it's compilation, it's all you need, but it's not creation as do authors, human authors. So I think that rights for such results of intellectual activity would have people who were trained in AI.
Okay, Elena, another question which we got from our partners is the question about, let's imagine that AI would get rights, yes? let's say about copyrights or whatever, but rights never exist without obligations and responsibilities. So what do you think if in future time some countries or states would decide that they can consider artificial intelligence as the author? So how would responsibility be, I don't know, considered? Because this China case, which you talked about, it's very interesting, yes? So AI, the result of AI creation, yes, financial report was violated, but the compensation got not the AI, but the creator of this AI. So that's the variant. What do you think about this collocation of rights and responsibility?
There were suggestions from investigators to give rights, for example, for electronic persons. And in 2017 or 2018, it was a first robot. It's called Genoid, and it has name Sophia, and it is it was granted with a citizenship of
Arab Emirates, I think, or another country.
Emirates, yes. And I think it is a big mistake because if you had electronic person with a citizenship, but you're right, Evgenia, you're right, exactly. We can't talk about the responsibility of machines. We can't talk about the intent of machines. And the most biggest mistake is when people write about artificial intelligence and do it in such ways. You can see a human here, you can see a human hand, we can see human faces on robotics, but AI is no more than many numbers, symbols. It's an algorithm, and it can have a pure intent. It can have it can have the intent of its creator. When the creator loads the possibilities, the assumptions of some actions for the AI, it will do in this way, but it can't have the its own pure intentions, and that's why it can't be responsible for its doings. The responsibility should carry the inventor who loaded all the algorithms and data in neural network or AI into it.
Okay, yes, I'm referring back to your slide about humanizing of artificial intelligence, to think like a human, to think rational, act like a human, act rational, maybe emotional. Artificial intelligence does not have emotional base, yes, because
emotions, they doesn't have proof, they doesn't have, don't you remember, I think, boson, Higgs bosons, вот частички вот эти вот, God pieces doesn't have a soul, and
it's about soul, first of all.
And talk about its for a long of time, but I think that all scientists who write in such ways, yeah, AI is almost human. We should we should mark them as an author. We should give them rights. And look at Sophia; she's a citizen of Emirates. I think it's populism. It's hype. No more.
What about machine learning? For example, if AI is, for example, the machine learning is inside of AI, and people may say that, okay, we have this input in the AI made by the author of AI, but later on, AI becomes something unique, which is not based on only the things which were downloaded in it initially. So now it's growing, and machine learning, is it an argument, or how do you think?
It's a scary thing. I am very scared, and I can explain why. The longer we learn our machine, the fewer mistakes there are in it. But scientists are always in a hurry. We can see an eternal races. Who is the first? And they don't want to try enough time to learn, to minimize their mistakes. And that's a problem. If you put in the AI the very big data, you can take only a couple of mistakes, but everyone is in hurry. I don't know why.
So it can run out of control. Yes, we can lose control, and that can be risky.
Yes, and it is already a classical example with the compass. The system of AI in the United States who predict forecasts recidive, and it forecasts not so much recidives for white people because it's based on statistics that Black people commit more crimes, but it mistaked, and it was a famous procedure, and the court admitted insolvency of this compass AI because it mistaked about Black men and white men. I think it was exactly because of not enough information loaded in. That's why it can't analyze in really big indicators. Yes.
Okay, so this mistake was really crucial, and so the United States ruled correctly. Yes, the mistake was withdrawn. Okay, Elena, I know that it's your postgraduate topic. Yes, you are writing a paper on artificial intelligence and
on its responsibility. Yes.
Okay, thank you. I just want to mention how you started today, and the end of your presentation, your English was fluid. So thank you very much. that's a really challenging thing to present your topic, which is very close to you, but in English. Yes, nowadays we don't have so much practice of talking English. We are writing English. Yes, we are writing letters to our partners, but we don't really talk. Actually, we don't really travel so much like it was like 2 years ago, for example. So that's a very big thank you to Elena for such a challenging presentation. I got a lot of new information. Thank you very much. I was not following the AI topic recently, but it's very nice to hear that still artificial intelligence is not considered as the author and it's not granted IP rights as a natural person. That's a good news for us for today. So we will follow. Could you please again show your book, which you started with? Because
my book,
the background of the Zoom sometimes doesn't show. Okay, so online business, you're written by you.
Yes, it's me.
What is right?
It's
okay.
It's Phoenix.
Okay. Now we know what to read, written by you.
Thank you so much.
Yes, thank you very much.